Now what this Rule 170 is all about, it's very interesting. So Rule 170 came into being in the year 2018, and this was as a result of Parliamentary Standing Committee specific to healthcare. They came across very high numbers of misleading ads in the country, and based on their recommendations, it was decided that some kind of an action should be taken against misleading advertisements. So on the Parliamentary Standing Committee's recommendations, the Ministry of AYUSH and the Drug Technical Advisory Board in particular of AYUSH, they brought in Rule 170. Now Rule 170 is little different than Drug and Magic Remedies Act or Drug and Magic Remedies regulations, because what Rule 170 aims to do is to take preventative actions. That means Rule 170 required that every manufacturer of Ayurveda, Siddha and Unani system of medicine, they had to take a pre-approval from the state licensing authority before issuing any advertisement. Now this is a very different mechanism of pre-approval, not existing so far in the country, and what it did was, it was putting rigor in the system of how AYUSH advertisements were being published in the country. The main requirements of these were that the advertiser had to fill in a form, and this form, yes, it is Form 26E4. So Form 26E4 is what the application is supposed to be, and in that application, every manufacturer of AYUSH system of medicine, they have to give the details of which ad they plan to issue, for which product the advertisement is meant for, what are the claims being made in the advertisement, whether the product is a licensed product or not, what are the textual references for making such a claim, what is the rationale for making such a claim. So in addition to that, they also had to give evidence of product safety, efficacy as well as quality. Now you can imagine that in a sector where so far the regulations were very weak and implementation was even weaker, something like this is being proposed. A pre-approval system, lot of rigor in claim substantiation, a pre-approval mechanism where an application has to be made in Form 26E4, and the state licensing authority will give their approval in Form 26E5. Based on that, that advertiser would get UIN, that is Unique Identification Number, and every advertiser is supposed to include that UIN number in their advertisement. And that's not it. There were many other restrictions also put, such as the advertisement has to comply with the Drug and Magic Remedies Act, of course, and in particularly it was stated that the advertisement should not be vulgar or obscene. There should not be any claims specifically making that this particular product increases height of an individual, or it increases the size or performance of reproductive or sexual parts of men or women for that matter, because you see all these sexual potency related claims being made in so many of these advertisements. So that was putting a stop to such advertisement. Rule 170 further also states that celebrities cannot endorse such products. The advertisement should not refer to any government officials, or it also should not refer to any government organization or any autonomous organization also, because so many advertisements you see in the past, you must have seen that they were claiming that this is approved by Ministry of AYUSH. So fundamentally Rule 170 was made to stop as a preventative measure of misleading advertisements. So I will follow through with a proper edited video, because I think my live stream is getting disturbed by my dog, because there is some work happening outside. So that's that for this live stream. If you're watching my video for the first time, please do subscribe, because I keep bringing lot of updates on advertising regulations, advertising laws in India. I bring lot of case studies also on my channel. I am Shweta Purandare. Thank you for watching.